Hello, I am professional attorney and very much amateur guitarist and drummer Scott Lesowitz, and Ed Sheeran won his copyright infringement trial. The jury found that he did not copy Let's Get It On while writing Thinking Out Loud. While Ed Sheeran defeated the copyright infringement claim, I do not think that this by itself will be that big of a deal for preventing, let's say, overly ambitious copyright infringement claims in the future. This is because, in my mind, the problem is that these cases get to the jury in the first place, and that when the jury does rule in favor of the plaintiff and finds infringement, the Court of Appeals tend to be very deferential and affirm those verdicts. The upside in winning one of these cases is so great that the plaintiffs do not need to expect to win every time in order to have an incentive to bring the case. Now, I don't think it was such a problem that the judge in this Ed Sheeran lawsuit let it get to the jury. There were more similarities between these songs than there were in other copyright infringement cases, such as the Blurred Line case or the case involving Stairway to Heaven and Led Zeppelin. The reasoning does matter. Think about it this way. You would not be happy with your child if he told you he knows 3 times 5 is 15 because he's 15 years old. What concerns me, though, is that when the judge denied the motion for summary judgment, which if the judge had granted would have meant the case did not go to the jury, the problem is that the judge seemed to indicate that Marvin Gaye and Ed Townsend might have copyright ownership of the 4-chord chord progression used in Let's Get It On, especially because the plaintiff's attorney admitted that there were at least 13 songs before Let's Get It On that used that same chord progression. Now, with so much of the publishing passing either to estates because people are dying that were making famous music in the 60s and 70s, or because people are selling their publishing rights, that there'll be more of these lawsuits because the high-profile ones have not been brought by the artists themselves. So my concern is that we still live in the shadow of the Blurred Lines case. Pretty insubstantial, the similarities, but the jury found for the plaintiff, gave him a multi-million-dollar verdict, and the Ninth Circuit Court of Appeal, in the face of a blistering dissent, by the way, affirmed the award, and in doing so emphasized how courts of appeal should be deferential. So in my mind, the only way to really prevent these cases from happening is either for the courts of appeal or Supreme Court to make it more difficult for these cases to get to trial, or that the trial judges start awarding attorney's fees to the defendants when they defeat the claims of copyright infringement. For example, in the Led Zeppelin case involving Stairway to Heaven, the jury found against the plaintiff, found that there was no copyright infringement, and it was upheld on appeal. However, the judge did not award attorney's fees in that case. Trial judges do have discretion to award attorney's fees, but it's not mandatory. Judges are to consider factors such as the merits of the claims, the motivation in bringing the lawsuit, and whether there's a need for deterrence. So with that, in honor of the late Jerry Springer, take care of yourself and each other.